Thank you for joining us today. I am excited to have somebody that I'm thrilled to be able to call a friend, David Schneider, who is an estate planning attorney by profession. He has been doing this for over 26 years. He has helped, this number sounds way too big, David, over 5,000 families with their estate plans.
Yeah.
I know firsthand from clients that we've shared, he has a really big focus on education. And not only does it say that on his website, he actually does that. He takes his time, explains what's going on, as opposed to just giving somebody a document that they can sign. He shows families how they can save tens of thousands of dollars with their estate plan. And for families that haven't done their estate plan, he's helped with over 300 probates. So we're going to get into that a little bit. So that's from a professional side, so you know who you'll be listening to. And from a personal side, we have a well-rounded individual as well. He loves Corvette racing and actually gets behind the wheel a little bit. I will not play poker with him because he has entered the World Series of Poker every summer, well, for a long time. So I will keep my money in my wallet and not play with you, although I'm sure I would have fun.
Sure, you bet. You're always welcome.
I think you'd have more fun with that. David and I also share an affinity for dress shirts that have flipped cuffs. So why don't we just go show those? Mine's a little bit more mellow, and yours are custom made. I was so impressed.
Yes, yes. Well, thank you so much for all of that. Very nice introduction. It's very flattering. And yes, I am starting my 26th year. Yes, I have helped in excess of 5,000 families with their plans. Um, yes, I enjoy the shirts. I do design my own shirts. I'm not the kind of guy that likes to be dressed like everybody else. So,
There you
but
go.
I love what you do, and you show up so stylish in your Robert Grahams, and I'm always looking at that. Go, God, yeah, I wish I would have had that shirt like Jeff has.
And when I see yours, I'm always impressed as well. So we're always checking out each other's shirts. All
There
right.
you go. That's all you need to know about estate planning. Thanks a
All
lot.
right. Well, thanks for joining us, everybody, and we'll see you soon. All right, so let's get into estate planning. And this is a niche of mine. Besides being able to help people buy and sell, a niche of mine is helping people that inherit property. This is a passion play of mine as well. So I'm really thrilled, David, that you're carving out time for me and for my audience to give some information. And I'm very happy to expose you to my listeners as well. So thank you for that.
It's my honor.
Thank you. Why don't we start at the very, very basic? What do people need to know about creating a trust?
Well, primarily, there is probably no family in the state of California that owns their own home and does not need to have an effective estate plan. Now, an effective estate plan includes the revocable living trust, pour over will, durable power of attorney for asset management, advanced healthcare directive. If you have minor children, it also would include what's called a nomination and guardian. This is what we round out a basic estate plan with. And the reason that I say literally every homeowner in the state is to avoid something called a probate proceeding. Now, a probate proceeding occurs when three facts are present. I'm sure we're going to get a little bit deeper into it, but just as a base understanding, three facts have to be present. You got to die. You have to own property in your name when you die, like your home. And the home or the property has to be valued greater than 184,500 bucks. That's it. That's the requirements here in the state of California. Well, there literally are not houses valued less than 184.5 because it's the gross value, not the net equity, gross value. So quite literally, everybody falls into this trap. So we want to have that estate plan to resolve avoiding the probate process, which, like I said, we could talk a little bit more in depth about later. Number two, we have a capacity issue problem. While we know essentially 10 out of 10 people are going to die at some point in time, right? That's a stat we can't get away from. 1 in 3 age 68 or older will have a significant period of incapacity before the end of the game. 1 in 3. Okay, that's a huge number. Now, I'm going to just go out right now and say, not it.
Not it.
Okay. So this is going to happen to people that we know. And if you have become incapacitated, we cannot now go sell your home, right? You can't sign the escrow docs, the sale docs, can't work with Jeff. Well, the home is owned by Bob and Susan. And Bob has been diagnosed with dementia. His Alzheimer's situation has advanced. Susan decides it's time to sell the home so they could relocate to a smaller place, assisted living. Well, she can't sell the home. We have a problem. Bob is titled on the home. Bob lacks capacity to act. He can't sign sales docs, can't sign escrow docs. What do we do? Well, if the home was owned by a trust, the trustee who remains capacitated, Susan, who still has her wits about her, she can act and she doesn't require Bob's signature because Bob is incapacitated. So we have the death issue, we have capacity issue. The third issue, when we deal with immature beneficiaries. Now, most people are thinking estate planning. We're going to talk about that when I get older, when I'm ready to retire. There's no guarantee that you get older. There's no guarantee that you get to retire. Unfortunately, we all know somebody in our own personal lives that's passed away at a very young age where we can all go, oh my God, that was so tragic. Well, these people leave behind children, or maybe they're adults, but immature adults. We cannot give $1 million to a 12-year-old. Cannot physically do it. Does that idea become any better when the 12-year-old turned 18?
Mm-hmm.
No. The people talk about the constants in this world. I think you've probably heard of them, right? Death and taxes. There's actually a third constant. 18-year-olds are not mature. They don't make good decisions. Think about yourself, right? When you were
That's
18,
why I'm
somebody
laughing.
had kids. Yeah, right? So it is these primary reasons why we need to put an estate plan in place. Everybody eventually passes, and there's going to be a cost to the family that we can avoid. Cost in money, cost in time, cost in stress. 1 in 3 persons are going to have capacity issues. Many of us have immature beneficiaries. Jeff, I just found out this is very, very happy news for me. I'm going to be a grandfather, May of 2025. I'm very much looking forward to this. But I've left to my daughter in the form of my trust. If tragically my daughter predeceases me, hopefully that's not going to happen. If she did, the trust agreement reads that her share passes to her child. Well, let's do the math. That kid's only so big, right? That kid cannot inherit my millions and millions of dollars. I don't have millions of dollars, right? The kid can't inherit. So we have to put these plans in place. That's a little bit of a long-winded answer, Jeff, but nevertheless, that's the 3 components that I try to keep clients.
What do you find is the most common objection or common reason why people that should have trusts don't create them?
Well, most commonly, I would have to just say it's a misunderstanding of what the laws are, or how these rules apply. Most people, myself included, tend to think, I'm not rich. I have a house. Sure, my house is, it's Southern California. My house is $1 million home, but I'm not rich. And, compared to the homes in Malibu or North Ranch or on top of the hill there, I'm just a regular person. I don't need that. Well, we know that the exemption levels are very, very low, 184.5, right? Gross, not net. So I think it's a misunderstanding of that. I believe that there is a misconception that having a will is adequate, which it is not. Wills go through probate proceedings. Um, there's probably a misunderstanding which comes from the idea that it's just going to my kids. So we'll just do that. We don't need to do anything through the court system. And then there's some lesser, um, well, lesser is maybe not the best word, but other reasons why. Um, if I talk about death, it means I'm going to die. So fear of our own mortality can sometimes play into that. And I don't want to spend that kind of money. If I go work with Dave, it costs, money. I'd rather spend that money on something else. Okay, well, then we'll charge your family 10 times. You know,
I was just going to say,
those are,
like, so for people that don't know, there is a statute, there's a I don't know, court ordered, but there's a formula that is required by the state for somebody that goes through probate. I think on just $1 million estate, probate fees are in the 40,000s, something like that.
there is a statute for what probate attorneys are paid. The probate attorney is paid 4% on the first 100, 3% on the second 100, 2% on the next 800, 1% of the next 9 million of the gross, not the net. So just to make sure, I said that several times. Let's make sure we're speaking English here. Home sells for $1 million. That's the gross. It had a $600,000 mortgage, so the family recognized 400 in equity. We're not talking about equity. We're talking about the gross, the full $1 million. So almost every estate that we deal with tends to be at $1 million. Many are more than that. So let me do that math for you. I did all those percentages. The math is 23,000 on the first million and 10,000 on every million thereafter. That's just the attorney's fees. Good times, right? $2 million estate, the family is going to owe me $33,000. But then the situation gets worse. All probate proceedings have somebody called a personal representative. This is the person who essentially hires the attorney and kind of manages the assets while we work through the process. The attorney does most of the work, but the personal representative does have to do some work, and they're entitled to get paid. They get paid at the exact same scale I get paid. So if I made 33, so did the personal rep. Now we took $66,000 away from the family. Now we can add in the fixed costs. So we have filing fees, which are open, close, bond, appraisal, publication, just the e-file fees alone. We're going to easily add another $5,000 on top. So where we're at, we're roughly $71,000 on a $2 million estate. And I think most people in our communities here, Jeff, yours and I's, Yosemite, Thousand Oaks, Newbury
Yeah.
Park, Westlake,
Yeah.
2 million is simply not a lot of money anymore.
Yeah.
Okay. But we're going to take 70 grand from that family. So when I bring home those checks, I tell you, my 3 daughters, they still think I walk on water. Now, 70,000, but that was based on the gross, not the net. So when we look at just the net, obviously that percentage is much, much higher. So when, I tell families, I can help families save tens of thousands of dollars by creating an estate plan. I'm not fooling around.
And according to my math, if 70,000 in that example, that's a little bit over 15%. So that's
Yeah, it's hellacious.
mind-boggling.
There
Mind
was an old car parts commercial. I think it was for Fram oil filters, but you can't quote me on this one. But you used to see the mechanic there, and he was wiping down his wrench, and he was saying, you can pay me now, or you can pay me later. They were trying to say that the Fram oil filters cost a little bit more, but you were saving yourself money. Well, this is exactly that, but it's a guarantee. It's not a maybe your engine will blow up. This is a guarantee. People pass, people own, probate courts are full.
When would be not that there's some magical time, but when is a time that somebody really needs to make sure that they have a trust? Is it when they buy a house, when they have their first child, something with assets?
When are they going to die?
Pardon?
When are they going to
Oh.
die, Jeff? People ask me that question all the time. And the reality is there's a number of different trigger points in our adult life. When we say I do, when we purchase that home, when we start the family, when we add on to the family, when we buy that vacation home, or when we're getting ready to retire. All of these are trigger points. What none of the trigger points recognize when we're actually going to pass away. Again, we all know somebody, and you talk and you say, oh, you hear the story. Oh my gosh, she was such a young man. She was such a beautiful young mother. Age is not a requirement to pass away. We don't all get to retire from our jobs and somehow die peacefully in our late 80s and early 90s. Okay, that's not a guarantee for a lot of people. So all of these points in adult life are triggers. At a basic, I would say for sure when the family starts it and buys real estate. So when they buy their first townhome, their condominium, their first starter home, all of these points are really when this becomes a more serious issue.
I think it would be great for people listening to go back to the list of trigger points that you just gave, because not only are they trigger points to start a trust, those are trigger points also when you have a trust and you absolutely have to update it, let alone other intervals. But those are great intervals for people to keep in mind that they need to speak to their attorney about updating their trust.
You bring up an excellent point. In fact, I just recently wrote a blog on this, that trust can become stale. The things that you wrote in 2005 when you created your trust, well, hell, that's 19 years ago, coming on 20 years ago. And you wrote in there that your brother or your brother-in-law would be the trustee, would manage the money for your two children. Well, your kids are now 26, 27. Things change. So while a good estate planning attorney is going to write these instruments to last you and hopefully last you a long time, they are not really designed to be set it and forget it. The trust that I write, Jeff, I sit down and I write a trust for you and your family this afternoon. It's designed to go the distance. Okay. You'll be 95. It still works. It's wholly impractical to think that you are going to die in the year 2054 with the same documents I wrote in 24. It's not realistic. People come in and out of our lives. Our thoughts change, our opinions change, laws change. So this is something that needs to be revisited from time to time. Now, that doesn't always mean change. but you have to keep it current. You got to stay up and at least make certain that the decisions that you made in '05, in 10, in 15, in 20 are still the right decisions for you today. Or it's not going to be as an effective tool as it could have been.
So, what pitfalls do you see when somebody comes to you after having a trust created by a different attorney, and whatever the reason is that they're not going back to them and they're coming to you with the trust created by somebody else, and you're going to at a minimum review, if not make changes? What are some of the common pitfalls that you see in creation of trusts by somebody else, not by you?
The probably the greatest thing that I see is not necessarily there's a failure in the document, but there's a failure of communication between the attorney and the client. One of the things I ask almost right out of the gate when somebody's brought me their old trust, and I'm looking at it and I say, Jeff, how much of this do you actually understand? And Jeff says, it's a trust, signed it. I think my house is titled to it. Most of the clients that actually come to me have told me point blank. They know they need it. They have really no idea what it says. And I'll ask, well, did the attorney explain the difference between the trust and the pour over will? Did he talk about the power of attorney? Oh yeah, power of attorney. That's when I die and then my mom needs help, right? No, that's not how that works exactly. And so I find that there's a real lack of understanding. When the client doesn't understand what it is that these documents are designed to do or why they're doing it, I find that there was a bad exchange of information back and forth, because it's almost impossible to answer the question if you didn't understand it in the first place. And if that attorney was not taking the proper amount of time to explain it, and not explain it in the legalese that these schmucks, we like to use, but you got to be able to explain it to the client so that it's usable for them. And when it's usable for them, they get it. When they get it, they can understand. And now they can ask intelligent questions. So it's not so much a failure of the document as a failure of kind of the system, as it were. Most of the people that will come to me with trust that actually don't own anything. If you have a trust and that trust doesn't own anything, you haven't titled your home, you haven't titled your bank accounts, your brokerage accounts, trust doesn't own anything, it is simply not worth the paper that it's printed on. It's not going to do anything. And why doesn't the trust own these things? He didn't tell me that we had to do that. Okay, so you didn't ask him about this. Well, I didn't know I was supposed to. It's a whole breakdown of communication. So it's usually not the documents that fail, it's usually the people in the relationship that's failing. So, I go through great pains to spend a significant amount of time with my clients. And I know that it's more than a lot of other estate planning attorneys do, because they tell me. And I spend a lot of time. This is what a trust does. This is why we are using the documents the way that they do. Here are some of the most common examples of what's going to occur. And I go through that step by step with every client. In fact, I'm very proud of this, Jeff. I don't know that I've ever mentioned this to you. I have helped over 4 dozen attorneys with their estate plans. And I work with them, and most of them come to me are married, not all of them. And I'll be talking to Bob and Susan, and I'll say, Susan, we all know Bob is the attorney, and Bob knows everything, right, Susan? My wife's married to one too. I understand how that works. And so, really, Susan, I want to spend a lot of time explaining this to you. We know Bob knows it. I'm going to explain it all to you. And Bob's going to be doing this a lot while we talk about it. And then he won't be embarrassed when he doesn't really know. He gets to act like he knows. And then I take the clients through it just the same as I would you and your family or anybody else. And because of that, I've gotten a lot of positive feedback from those families, the attorneys' families, and that they are appreciative, that they get it. That, it wasn't just me and the attorney hobnobbing, remembering the time that we were in school and we did and yeah, sign right here. No, it's I take the time to go through it because I feel that's super important to really understand it. Then you buy into the program, and then you're educated. And educated clients do two things really well. They follow instructions. So when I explain to them, hey, I just retitled your home in the name of the trust, but you need to go to the bank. You need to talk to your financial plan. You need to talk to your life insurance agent. They understand the value of that, and then they follow through, and the plan works. The other thing I like about educated clients is that they go out and tell somebody else, right? They tell somebody, hey, listen, we worked with Dave. Dave's a good guy. He explained it, and that's how I built my practice.
So one of the things that you're mentioning that comes across to me as a shortfall, which you just referenced, is funding the trust. And when people don't get the details, like you said, I didn't write it down, but you basically said something like a trust not having anything in it,
A
where
trust that's not funded.
yeah, so somebody listening may say, well, what do you mean the trust doesn't have anything with it? Just because David or another attorney creates a trust, that's the start. That's not the end. Just so everybody realizes that's listening. It's what's inside the trust that counts. And if you have the best trust that was ever written and you don't put anything in it,
Right.
it doesn't do anything for you. So
It's a
that's called
two-step process, right? Step one, create the trust. Step two, fund the trust. You have to retitle the assets into the name of the trust. You are exactly right, Jeff. I put together the plan for you. I put it in the binder. It's got your name on it in gold. It's quite stunning, really. You put that beautiful binder up on the shelf. It doesn't do jack. Now, part of the process when you work with me is that I retitle your real estate for you. I do that as part of as a manner of road. I do it.
wow, very nice.
Well, here's the thing. If I leave it to the layperson and they muck it up and now their property taxes get flipped around, it's a really big deal to unmuck this problem. So I just do it. Any given year, I'm going to transfer 300 properties, and I know what I'm doing. And I transfer property in Ventura County, LA County, Santa Barbara, Clark County, Nevada, Maricopa, Arizona. We're transferring property in South Carolina and Tennessee. I got clients that live all over the place now. They've moved out of California, but I still help them. So I know how to do the real estate. I'm going to do that for you. What I cannot do is I can't go to Bank of America for you.
Right.
I can't talk to Schwab for you. State Farm Insurance for your life insurance. I can't talk to them, but I'm going to teach you how to talk to them. And I teach you what to say, how to say it, and when to say it. So that's all part of my process is that once we have these documents in place, I'm usually going to spend about half an hour just walking through. This is what you're going to say to these other financial entities. This is how you do it. And I give you a checklist with actually my phrasing right on it. Say these words, speak like Dave, say this, and go get it done.
It's so valuable.
Well, I think it is. I think it's appreciated. Um, Probably the hardest part of what I have to do is to relay all this really boring information to somebody and keep them from dozing off.
Missing the
Yeah.
most important part.
Right. So
Yeah.
everything I do is kind of designed to keep people engaged, including, sometimes they'll answer a question. I say, you're wrong. What? Yes, because I need them to, kind of key in and come
Wake up.
into the things
Yeah.
that I'm trying to teach. Because I admit fully, it's just not that exciting. It's super important. That did not make it exciting.
So I think this is a perfect spot to give a PSA where anybody listening that has a house, the odds that you did not refinance your loan at least one time in the last couple of years, I'm going to say has to be zero. So everybody's done at least one refinance. Please reach out to me, reach out to whoever helped you with your trust. Make sure that your home is in your trust, because a lot of times a lender will require you during the refinance process to take your house out of the trust to do the refinance. And then once the new deed gets recorded, they'll let you put the house back in the trust. They
But
don't
they
do it
walk
for you.
away.
They
Yeah, they
don't do it
walk
for you.
away.
Exactly. So please make sure, because there's there's too many times when somebody calls me, especially when it comes to an inheritance, and it was, the parents' home, and they say my parents have a trust, I'm the trustee, and I reach out to the title company, and the title company says to me, "What trust?"
Exactly.
House
And
got
this is,
taken out, never got back in.
continuing on that thought, something that I hear quite often is, I'm sure that it is. Well, I really don't know why you're sure. I don't know what gave you that confidence to believe that. Well, the broker told me. Yeah, this is just not. You want to spend an extra 10 minutes trying to figure this out. And
Exactly.
sometimes, for a layperson, they may not figure it out, or they could even look it up and find an old document, not realizing that they're looking at the newest document. So I would strongly recommend calling somebody like Jeff. Go ahead, call me. We have the ability, we have the tools to go look this stuff up, and we can see what the county actually sees, what the title companies are looking at right now. We know what to look for. Seasoned professionals, seasoned realtors, Jeff with Team 805 is absolutely somebody that you should and could rely upon to make certain that you're getting the proper information. So excellent PSA, Jeff.
Thank you. Let's fast forward for a second. Somebody passes, the they have a trust. They Now somebody gets tasked as the trustee, which is, I'll go ahead and say, a thankless job, but I mean, I don't know if we're going to talk about
Can
that
be.
later. What should that person know? And hopefully there's no co-trustees. I don't know why people
Yeah.
think that's a good idea. Um, Somebody's a trustee, so now they have to administer the trust when the last person dies. What should somebody know about administering the trust? Should they try it on their own? What should they know about trying it on their own? Should they hire an attorney? What should they be thinking about when they're making the decision on how to best administer the trust?
All right. I feel these calls every week. So I think the very first and foremost thing is that every successor trustee should speak with an attorney, at least for a short Q&A before they decide to try to take this task on themselves. You mentioned thankless, and it certainly can be. I don't want to dress it up, but it doesn't necessarily have to be a difficult task. If you think it through, and if you are methodical in your application process, I think it can be done in a reasonable amount of time, and it doesn't have to be overly difficult, and you don't have to put up with a lot of stress from unhappy siblings, heirs that aren't going to get along. Start by speaking with an attorney who has experience in administering an estate to develop a more or less a checklist. And I'll tell you that the first thing that the majority of successor trustees will miss or will not do correctly is that they will not give out the required notice. California Probate Code requires that a formal notice be given of the administration of the estate. which requires some very basic information. But what it does is it also starts a clock, a short clock, on the ability to challenge the trust. It's a short clock, it's only 120 days. If the notice is never sent, or if it's sent incorrectly, the clock never starts. That means that the successor trustee could be pulled into litigation for an infinite amount of time because the statute never ran. So it's very important to simply get out a proper notice. And proper notice has to go out to every person whose name appears in the document. Doesn't matter if they're getting, their name appears. Jeff, I know that your trust says, and under no set of circumstances should David Schneider ever get $1. When you pass, your successor trustee has to give me notice. Why? My name appeared.
Wow.
Doesn't mean I'm inheriting, it just means my name appeared and I'm entitled to notice. Every person whose name appears in the document or was related to the decedent to the second degree of kinship, which is typically going to be children, grandchildren. Well, Jeff, I know you got grandkids and they're 3 and they're 4. They still get notice. It
Wow.
has to be physical mail that's addressed to them. Yeah, I know. No 4-year-old's gonna, they might color on it or something. Yeah, it's still a requirement. And if you have that ruthless brother who is always ever looking to really screw you down or take all of everything, they will use any and all of those tools against you. You mentioned co-trustees. Yes, I spend a significant amount of time trying to talk clients out of utilizing co-trustees. Most clients have this unfounded belief that their children are great and they're always going to get along and they're always going to work well together. I don't know where this comes from because this is usually the single largest problem in the probate court, co-trustees who can't get along. In fact, I find many brother-sister combos would not even be friends with each other, but for the parents. Yes, we share some DNA, but after that, they have nothing in common. One's red, one's blue, one's, pro-gun, one's pro-green, whatever it is. So you're asking these people, to work together who are not well suited for working together. It's a false sense of, I don't know, security. I'm not really sure why they do that. But yes, if we get it down to that single successor trustee, sit with the attorney, develop a checklist. Now, if they want to subsequently continue to work with the attorney, all right, well, David, we'd like you to send out the notices. We'd like you to help us administer the estate, communicate with the other beneficiaries. Then we can do those things and help take some of that stress off of you. Now, the successor trustee, they still have to go to Bank of America. They still got to go talk to these institutions. But now we're scripting out usually what they say and how they say.
So again, some things for our listeners to be keeping in mind, and I have been taking some notes. One thing that's been shocking to me is how family members don't get along, where maybe when the matriarch or patriarch of the family was alive, everybody was kept in order. And then once that second parent passes, people tend to not get along. So I mean, that's something like you were referencing that. I think that's something that people should keep in mind as they're creating their trust.
When the referee is off the ice, Jeff, people take punches, right? The elbows come up a little bit, right? When the referee's not there. So this holds true throughout life.
Love the hockey reference. And just for people to realize also, when it comes to administering the trust, first of all, somebody probably has a family to take care of, probably has a career to take care of.
Sure.
Administering a trust takes time. Please do not think about how can I save money. There are plenty of places in life to save money or to cut down expenses. Please keep in mind, administering the trust, do you know what you have to follow in order to administer a trust? And the answer is California
Most
probate
businesses
code.
know. Yeah.
Who knows
Most people are
California
not going to know
probate
that.
code besides on this call besides David? I don't know it.
Yeah, it's a select number of us, that's for sure. It's you know the old saying, Jeff, penny wise and pound foolish, right? So this is not, yes, this is somewhere where you can save some money for the family by doing everything on your own. We can just about guarantee you it's going to take at a minimum twice as long. And more than likely, mistakes are going to be made. Sometimes the mistakes can be costly. Um, Sometimes the mistakes, as I said, like with the notice as an example, leave you on the hook for all of your sisters and nephews' dissatisfaction. So there's a number of costly errors that could be made. Penny wise, pound foolish.
And I'll share a statistic. I don't track, so I'm just going to guess, and you can share what your experience has been. I'll say when I get contacted to sell a property that is inherited, I'll say probably 70% of the time, the main heirs, brothers and sisters, have attorneys. It's not we all get along. You're going to administer. We'll have an attorney help you administer, and we're going to get whatever the trust says. That is the exception to the rule, which if I hadn't had the experience that I do, I'd say can't be right. It can't be that high. It's so common that so when David is saying from an administration standpoint, from the successor trustee standpoint, very, very important. You know what to do and you do it, and you do it by the letter of the law, or else you're opening yourself up for a lawsuit for just trying to administer the trust.
You think that you're doing the right thing, and you make a mistake, and you're thinking, I made a mistake, and it's how my sister is going to collect this. It's not just my sister. My sister is married. She sits across the dinner table from her spouse, who has his or her opinion on what that feedback is. And of course, they're having their hair done, and the stylist is explaining to them, oh, the exact same thing happened to her best friend's best friend. And in that case, this happened, and everybody got screwed. And this sounds like the exact same situation. I hear that one all the time. It's exactly the same. And by the way, it is never exactly
It
the
can
same.
never be exactly the same.
It's never, never. But they say that all the time. And so there's always these other outside influences that are pressing upon you. And you could be doing everything perfectly. But if there's even the misconception that it's not be done right, then you're also going to fracture all the relationships. If there is any kind of a chink in the armor, the probate experience will be a spotlight on it and will expose everything that's wrong, every fracture of this family, every mom always loved you best scenario.
Can
I
somebody
stress that.
still, I don't know if it's somebody, can when administering a trust, so somebody has a trust, could that still end up in probate court?
Oh, sure. When there is a dispute that's ongoing and it can't be resolved,
Hmm.
somebody might bring a suit to have the trustee removed or the trustee censured, or to force an action by the trustee. Now, there's also the disinheritance and no contest clause. All trusts, all wills contain such a clause, but most people do not understand how these are actually applied. So we see lots of trust contests being filed, but then ultimately getting tossed. Most people would take a view of the disinheritance or no contest clause in a trust as saying, I'm the trustee, and Jeff, you're supposed to receive $50,000. No, that's not right. Dad said I was supposed to get 75,000, and you sue. And then the successor trustee says, ha ha ha, you sued, so now you get nothing. That is not how the disinheritance clause works. The disinheritance clause or no contest clause is designed when, let's say again, Jeff, you're going to bring a challenge that mom or dad was lacking capacity when they created the trust. They did not have their mental faculties when they created the trust. Or two, that they were acting under an undue influence, a pressure that was being applied to them, forcing them to act in a way they would not have otherwise act. You know, Dad, that if you don't give me the house, you know, I might just move you out, go live with your sister Doreen in Bakersfield, you know, or say something where maybe I'm in that position of control and I'm applying a pressure to him so that he says, yes, my son David gets the house and Jeff gets my coin collection. You know,
Right.
something that's, very disparative. And that would be an example of an undue influence. So the disinheritance or the no contest clauses that get thrown into the probate court all the time actually have a very, very narrow application, a very narrow reading to them. But most people will throw that around to try to keep their brother in order or their sister in order. Yeah. You want to challenge? Go right ahead, because I'm prepared to put a big zero in the ledger for you.
Got
That's
it.
not how it works.
I did not know that. Thank you.
Yeah, sure.
What are three mistakes not to make with a revocable living trust?
Wow. Okay, just three of them. Here we go.
Oh,
Um,
if there's more, but I'm sure
yeah,
that could be a really long conversation.
yeah. We might have to get another reel of tape for that one. There. Let me just show you how old I am. Reel of tape, right?
Exactly.
Um, First and foremost, I'm going to go back to the funding, not properly funding the trust, or this belief that you created the trust and somehow that was all encompassing and everything magically or automatically transferred. There is no such thing as automatic in my world, in my area of law. There's nothing that is automatic. Everything requires something. You want to retitle the home, you need to sign the deed. You want to change the bank account, you got to go to the bank. You want to change the beneficiary on your IRA or on your life insurance, you have to speak to the company to do that. Everything requires something. Most plans fail from a lack of funding. In fact, that's what I tease. That's how you make the corner of my desk here. This corner is the probate corner. And actually, the pile's a little bit low right now because my assistant has several of the files that she's working on. But this is the corner of my desk that pays the big money. You don't want to end up on that corner. How does that happen? You didn't fund the trust because the trust itself does not stop a probate proceeding. Number two would be allowing that trust to grow stale. So we wrote it. We wrote it in 2007, and here we are in almost 25, and we never changed anything. Half the people that we named in there are dead already, because we named my older brother, and then we named my sister-in-law, and then we named his brother. I don't know. People that, the trust is 20 years older, Jeff. You're 20 years older. Everybody you named in the trust is 20 years older. That's the deal. We all age at the same rate. So as it's getting old, so is everybody else. Probably number three, this is not necessarily the trust that we create, but this is something that I've really seen a big trend in somewhat recently. And you've probably seen this a bit too, because it has to do with real estate and our old friend property tax. So somebody inherits this home. It's in mom and dad's trust, and it says divide everything equally between our three children. And mom passes, and then dad subsequently passes, and they leave the home in that trust. They continue to rent out the home. They don't change anything. They don't tell anybody. They're trying to keep those property taxes down where they were. Most of the trusts that are written, and when I say most, I mean in the way upper 90%, like 98%. These trusts are designed to distribute the assets when the settlors, that's the people that create the trust, mom and dad, when the settlors die, the children vest. No, snap wasn't very good. My snapper's not
Work
working.
on that.
I'm gonna have to work on it. Sometimes it really pops. The children are immediately vested in that property. Now, they haven't changed the title of the property, but they have vested in the property. And then they will tell me almost 10 out of 10 times, yeah, we don't have to worry about that because that property's in trust. That's not how that works. Now, Jeff, you own 1/3 of this property with your two siblings, and you die. You were the one with all your experience, you were managing it. So now your siblings say, well, I think we ought to probably sell it. Right after the probate proceeding. What probate? The home was in trust. Yeah. But Jeff had a vesting. Jeff had a legal interest, a full 1/3 interest in this property. Okay. All we got to do is clip 185. So that's what? A $600,000 home. Okay. It's hard to even find that home in this community.
Right.
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 So now all of a sudden this property has to go through a probate proceeding. And yes, the tax man is going to catch up. Right. They're going to get property taxes at least for the last 3 years. That's how far they get to look back. So be prepared for that little extra $35,000, $40,000 little pink present there because it comes in pink. That's always fun. And it could be that, of course, Jeff has, you have a young daughter, I remember. She's got to be what, about 12 right about now?
Just about. She's 10, yeah.
Okay. And she can't inherit,
Right.
but she did. She inherited from you that 1/3 of that home. So now we're going to have to not just run the probate petition on Jeff's estate. We're going to have to set up a guardianship provision
Oh boy.
for your daughter.
Wow.
And then we have to get court permission to see if we can sell the house. And that's not a rubber stamp. So there's just all kinds of trickle down problems that are occurring. So again, not necessarily a problem with the estate that we create. I know that's kind of how your question was phrased. But this is something that's really important that I've just seen repeatedly over and over again this year. And to be fair, I see it every year, but seemingly this year I saw it a lot more. And I think it was exacerbated by the fact that property taxes are very high, that people are trying to keep those properties. They don't want to tell the lenders because, dad had that loan from 2021 at 2.8%, right? So we're just going to keep paying it. We're going to keep the property taxes where they are. We're not going to really tell anybody. And then the shit hits the fan. So those would be my big three.
And while we're not going to get into taxes, since everybody's situation is going to be different, everybody listening should keep in mind there are two different taxes. Well, there's more than two, but the two big taxes that are at play are going to be capital gains and also the real estate property taxes. And this is why this is going to sound corny and trite, but that's why what David does is not called estate emergencies. It's estate planning. And he just rattled off about 5 things in sequence that maybe somebody could have missed listening to this for the first time. And all of those can be avoided with proper planning. And without proper planning, an incredible mess, not only a mess with that will take you more time to unwind, be very, very expensive to unwind as well.
And if I could just mention on taxes just very quickly,
Please.
most people will say, well, we don't want to pay more tax, or we don't want our kids to pay more tax. Tax is a very broad term because, as you just mentioned, there's income tax, there's capital gains tax, there's property taxes, there's something I deal with called federal estate taxes. And so each of these has a different set of rules. And working through qualified professionals, a real estate professional, Jeff Landau, Team 805, I can't say it enough. You understand the concepts that are involved in dealing through property taxes. And you understand and can advise the client, hey, these are the things that you need to do. And I would help clients to understand when you sell that property, if you inherited it and you receive what's called a step up in basis, you're going to have less capital gains tax, maybe no capital gains tax, versus dad gave you that property a year before he died. You know, what are the ramifications from doing one thing or the other thing, right?
Hundreds of
And
thousands of dollars of an error. Sorry for interrupting you.
no,
Triggered me.
you're spot on,
Yeah.
Jeff. You're spot on.
Yeah.
Client called me recently. He wanted to give his granddaughter his apartment building in the Palisades, or not the apartment building, just the townhome, the condo in the Palisades there. It's worth, I don't know, it was paid off, and I think it was worth 800,000. It was probably like 600 square feet, which $1 million for whatever it was. He wanted to give it to his granddaughter, and I tried my hardest to say, listen, Bill, if you let her inherit it, she's going to get it all, and she's going to get it at $1 million basis. She's not going to owe anything. It's $1 million off your estate. Let's do that. No, I think it's really important that she gets it now. So, well, why can't she just live in it and you'll give it to her? Well, no, she really needs to own it now. Well, then you have to understand the tax consequences of doing this. Now, his decision's not important so long as he understands the consequences of if I choose path A or I choose path B. That's what I'm talking about when I talk about talking to Jeff, talking to Dave, understanding what your decisions are. We are not here to make the decision for you. We are here to
Right.
educate you so that you can make the best decisions possible. You know, I work with a lot of professionals, and Jeff, I'm proud to say this and say it to all the people that are listening. You and I have worked before. We've had shared clients, and I know what the clients say about working with you, working with Team 805, and they just speak so highly, and they come back and they tell me, you know, I really felt informed all the way along. I knew what was going on at every step, and Jeff really worked with me. And Jeff told me where stuff's going to work, where it's not going to work, and really helped guide me. He didn't push me. And that's the reason I told that story. You didn't push, you guided. And that's what an effective professional does. I don't care if they're an estate planning attorney, a realtor, that they're a financial planner, that they're your divorce counsel. I don't care who they are. A solid professional teaches and guides. They don't push. And that's what you ought to look for in your professionals. And the things here that we're talking about, the concepts that we're talking about, they're not simple and they're not intuitive. Okay. You need somebody that can help.
Thank you. And this exactly why you and I are recording this to share for people is I don't want to say it necessarily comes naturally for you and I, but you and I are, I mean, you're doing this your whole day. I do this quite a bit in what I do, and a lot of people may do this once. So
Right.
yeah, very, very important. Like you said, I hate being trite, but there's a reason why some things are the penny wise, pound foolish. Um,
Absolutely.
Now, next year, I think it's in April. There is going to be an increase in the limitation for, I don't know if limitation is the right word for probate. Is that the threshold that's going up next year, or is that still being
There
planned?
is, there is some discussion
Okay.
on this. It has not been, ruled into or ruled out of possibility. The threshold that triggers the probate proceeding, you've heard me refer to it now a couple times, 184.5 or round off 185,000. In the 26 years I've been doing this, this number has changed twice, and it has not changed significantly.
Wow.
When I first started practice in 1999, all right, I'm going to really be pressed here, but the threshold was, I want to say, 151,000.
Okay, so it
Then
hasn't
it
changed.
changed. It
Wow.
changed somewhat early on in my practice, and it went to 166,250. And then it changed again, I want to say around 2012
Hmm.
to 184.5. Now, don't quote me on those dates, but we have gone 10 years at the present level. And you can see that from each time, it did not change demonstrably. Now, if we look at average value of a home in 2010 in this community, 2010 might not be the best year to use since that was coming out of the Great Recession, but
Right.
it would still be reasonable to say that the median price of a home in the community coming out of the Great Recession was $500,000. And it was probably higher, but that's not a that's not an unuseful number.
Right.
Okay. So even at that level, it was above the probate threshold. Now, our real estate has risen dramatically, doubled. Median price of a home, I think here in Thousand Oaks, where my practice is based, is what, like 900, 950, something like
Yep.
that. And yet, if that number, the 185, doubles, so what?
Exactly.
You know,
Exactly.
it's still going to go through the probate proceeding. And just going back for just a moment, remember the money I told you that I get? That's on the value from zero to whatever the value is. It doesn't start at 185 and then go. It's not like the 180 first 185 is free. The attorney doesn't get. I get paid on 100% of it. So the fact that the threshold is going up is going to affect almost nobody in
Wow.
our communities.
Okay.
And that's if it goes up. The state bar, the judicial council, these bodies that weigh in on making these changes, they really have their hands full right now with some other more pressing issues than the probate code. And this is not something that garners a ton of attention in Sacramento.
Uh, Trust me, I could go on and on talking with you, whether it's personal or about business. I do have one more question,
Yeah, shoot.
but you've mentioned a couple times the pour over will, and I'll let you know my understanding. I'll be vulnerable. I could get this really wrong. That's okay.
Let's
Um,
see.
I would assume that the pour over will language is something like, oops, anything that I didn't put in, please court assume that I meant to.
No, that's not what it is.
Bam.
But
I'm not an
but
attorney.
but your assumption is echoed by most of the people I speak to.
I'm
Most
so
people
glad
think
I
that
asked.
yeah,
Okay.
most people
Right.
think that that's what it is.
Perfect.
Yes, the pour over will names the trust as the beneficiary. But what it is designed to do is to deal with small titled property, which is underneath our probate threshold. The most common example is going to be our car. Most of us do not drive Lamborghinis and Ferraris. I do not. I don't know, Jeff, maybe? I
My
don't
Miata is not,
know.
no.
So our vehicles are significantly under the probate threshold. We could title our vehicles in the name of the trust. You could certainly do that, but that requires a trip to a very special place. I like to refer to it as America's favorite vacation destination. Where do we go to title cars?
EMV.
The DMV. So supposing, Jeff, I made you title your Miata in the name of the trust, and well, you sold it. You upgraded. It's time to get the new Miata. You're going to now move to the MX-5 or some other thing.
Yeah.
What do you got to do again? You got to keep going back. Well, how many times would you like to go to the DMV in this lifetime? Yeah, exactly. The big goose egg, right? We don't want to do that, right? So, I'm going to tell my clients, you can go ahead and leave the Miata titled in your own
Okay.
name. So this is the problem. If the car is titled in Jeff's name and Jeff dies, can the trustee of Jeff's trust sell the car? And the answer is no. Why not? Because the car was not titled to the trust. Well, then who can sell it? Well, the only person on the title is Jeff. So the only person who can sell it is Jeff. Well, Jeff happens to be, in this example, dead. And we all know dead people are not very good at selling cars. They never get top dollar. Well, mostly they really don't know how to haggle. And in any kind of a negotiation, they tend to just lay down.
Oh, uh-oh.
Yeah. Yes. Well, Jeff, they're not all golden. So anyway, so what we're stuck. What do we do? Well, that's when we utilize the pour over will. And the pour over will designates somebody called an executor. Now, the person that you name as the executor of your will is the same person that you named as the successor trustee of your trust. But the successor trustee of the trust handles the trust assets. The executor of your will handles the decedent's assets. The decedent is not the same as the trust.
Got it.
Coupled with that is a third document. I don't want to take you off too long here, Jeff, but I think this is important for the people listening here.
Please.
It's the power of attorney. The third kind of area of property, okay, you talk about your home, these assets that are large. You can talk about your personal property, your car and your boat. The third area of property is our tax qualified assets, the IRA and the 401k. We have some big corporate entities in our community here. Amgen, Bank of America, American Airlines has a big influence out here, Disney. All these people have these really nice, well-funded 401ks. These assets cannot be titled in the name of the trust. These assets must be owned by a human. Right? Not owned by the trust.
Good info.
So if we own the asset and then we are diagnosed as lacking capacity, we've become incapacitated, we can no longer manage the 401k. Well, can the trustee manage the 401k? No, it wasn't titled to the trust. Well, then can the executor of our will manage the 401k? No, we're not yet dead. Can the beneficiary, my wife, can she manage the 401k? No, I'm not dead. What do? We've created a third tool called a durable power of attorney for asset management. And we designate somebody called an agent. Third term, right? We had trustee, we had an executor, now we have an agent. And then the agent can interact with Fidelity, Schwab, whatever, to manage that 401k for our benefit during our period of time when we've become incapacitated. Now, that can be the same person in all three of those roles, but these are three different tools. And I liken this to this, and this is the last example I'll give because I know you want to get going on time here. Jeff, I'm pretty sure you fix things around your house, right? You're a handyman.
Yep.
You got a hammer in your home?
A hammer? I have a hammer.
Do you have a screwdriver?
I have more than one.
Do you have a wrench?
Yes, I do.
You know what? I have those same things here in my office. I have a hammer and I have a screwdriver and I have a wrench. Well, use your imagination.
Okay.
All right. Hammer, screwdriver, wrench.
Okay.
Jeff, you are allowed one word and one word only to describe my hammer, my screwdriver, and my wrench. What one word would you use?
Tools.
Tools. I concur. Jeff, you and I both agree that we could use one word to describe my hammer, my screwdriver, and my wrench. We agree that that word is tools. Jeff, would you agree with the statement, sentence, that one person, one mechanic, could hold all three of these tools in their hand at the same time?
Yes.
I appear, in fact, to be doing that.
Sounds like a magic trick. Okay.
Well, yeah, I'm so good, I'm ambidextrous. I can do it with both hands. Now, Jeff, we have both agreed that we can call my hammer, my screwdriver, and my wrench by one word, tools. Further, you and I both agree that one person, one mechanic, could hold all three of these tools in their hand at the same time. So here's the $14.38 question. Jeff, are these three tools interchangeable?
Absolutely not.
No, they each have a very separate and unique function, don't they? My trust, my pour over will, my durable power of attorney. One person could be in charge of all of those things, but each has a very separate and unique function. There is no interlap, there is no crossover. And those are the types of things, and the way that I teach or try to teach my clients about how effective estate plans work. And when you can start to get your hands around that, and it sometimes takes more than one telling. When you can get your head around that, then the estate plan is going to become much simpler.
And there's an example of how you educate. It's not only on your website, you actually do it.
Thank you.
Kudos to you.
This is what I do. I enjoy doing.
Let me wrap up with one last question. It's a really
Yeah,
important one. If somebody's been intrigued by this podcast and this recording and this video on YouTube, they have some questions that I didn't ask, or they want somebody talented like you to create an estate plan for them. How can they reach out to you? What is the best way to reach you?
please. There's a couple ways. You can shoot me an email. You can call my office. You can go to my website. You can read about some of these things I'm talking about. You can read the blogs. You can go to my YouTube channel. I've got 120 plus videos up there where I talk to other professionals, not unlike you, Jeff. And you can also see the videos where I talk about these documents. I'll probably tell some of the same stories I just told here. So my website is drs-law.com. So it's a dash, not a hyphen, or not an underscore, or it's a dash, a hyphen, not an underscore. You can call my office, 805-374-8777. Shoot me an email, D Schneider, so DSCHNEIDER at drs-law.com. Just reference you saw me on Jeff's Team 805, and I'll know exactly what's going on and make certain that I get right back to you.
Beautiful. Hopefully, this has given a great deal of education to our listeners. And if you have not created a trust in a while, or if you're not in touch with the attorney that created it for you and you're looking for a new one, you're looking at that new one, please reach out to David. Really appreciate your time, appreciate your expertise, and above all, appreciate your friendship.
Well, Jeff, it's just really been fun to chat with you about this stuff. As you can see, I'm passionate about it, but the other thing that I'm really passionate about is working with other quality professional people, and that's what I think I have in you, and not just our friendship together, but knowing your work ethic, and I like being associated with people like that, and you're top notch. Thanks for the opportunity to be here.
Thanks so much, David, and thank you everybody for listening and or watching. Till next time.